So the next session is titled Wills and Estate Planning, Protecting Your Loved Ones and Your Inheritance. Now, normally we want to hear about wills when we are on the receiving end, not when we are the signatory to that will. But it is a necessary part of life. You know, the minute you're born, for some of those who believe this philosophy, you begin to die. The minute you start working, you begin to prepare for your retirement. But the minute you're born, you start to die. And we all have to die sometime. But if we love our loved ones, then we will make adequate preparation for their welfare after we're gone. So Mr. Ferron Lowe, a well-known attorney at law, will now come and make a presentation, not using the technology. He will just use his cuff. So he gives something off the cuff. So let's hear it from Mr. Ferron Lowe.
Okay, thank you, Mr. Johnson. So, my dear friends, so we work hard, right? We accumulate a lot of things. We call them property. And the property can be broken down into classification. The real property, which is land and anything attached to land, so a concrete house, so that's the real property. And then we have personal property, which is like Mr. Johnson's watch, your wedding ring, your cars, and shares in companies. So that is personal property. But what we do, so we continue to accumulate and we don't look down the road. We want, so everything is fine and dandy, and all we know is that there's a nest of confusion waiting in the event that, as we say, broops. And these days it's like broop, 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 all over the place. So here what? So in your lifetime, you can do several things with your property. I would often advise clients that when you have these things and you have children, then consider giving them while you're alive. But you know what? If the boy rude, and that girl just cuss, and she packs her clothes and she go and move in with a man, and so on and so forth, therefore, I done with she. But we shouldn't use those, aspects of family relations to blank people. But it's advisable that if you have land, right, in particular, and if you have a lot of land, and you have several children or people, you should really try to distribute that in your lifetime. And those are called deed of gifts, right? So, of course, we can't go into the nitty-gritty of that, but it's a deed. So you're conveying the property to the person while they're alive. Now, if you don't want to do that, if you really want to do that, then you have to come to a lawyer, and you could come to me if you wish, right? And I will tell you, one of the best ways of securing, settling your children or your relatives after you die is by a will. Because a will only takes effect when you're dead. When you die, you can change it tomorrow. You can sell everything you mention in there as real property the next day. And that is something a lot of people don't realize. A will is an intention of what you want to see happen with your property when you pass on. But we afraid wills because we feel we go dead, right? And there is a statement that doctors are the worst patients, and I think lawyers are the worst clients. I see a colleague of mine is, are you there? Right? And many of us, we might advise people on making wills, but we don't have wills ourselves. So that's something else. But the will is important because you see, in a will now, you state exactly what you want to see happen with your property. And it is advisable you be as specific as possible. But let me make this point here. Sometimes you feel a will has to be so formally done. There are some formalities that are required. There's some requirements that must go into a will to make it valid. that it will be accepted by a court and you will be granted probate, etc., etc. But it can be written on any piece of paper. So even a fig leaf, as our late Ovid Gill used to say, so long as it has it. So you could go in the toilet and, you know, you have diarrhea and you end up, you feel you're going to die inside, you know. So you take out the toilet roll and you start to write your will. But you got to call somebody outside to witness it because you need 2 witnesses. So I don't know how they're going to go on. But the point is, the formalities is not the paper. It could be on any paper. This, as we're standing here today, and so on. But there's some certain requirements. There must be someone making the will. And if it's a man, we normally call him a testator. If it's a woman, we say testatrix. Okay? But then here are the requirements. There must be a name. There must be a date. Right? There must be a signature of the person who's making the will. And there must, in particular, 2 people witnessing the signature in his presence at the same time. He can sign the will before, or he can sign it in their presence. If he signs it before, when he comes to them, he can say, this is my will. He's acknowledging, I have signed here, and I want you to witness my signature. If the will has only 1 witness, it falls down. Get the point? There must be 2 witnesses. And if you have an Inding kind of family and there's fighting, make sure that if mommy had a stroke last week and you want to do will this week, don't just go by a lawyer to do the will and somebody in the office witnesses. No. Get the registrar of the court or a magistrate and so on, one of these higher officers who will be there to, you know, really establish that is this person mentally capable at this point in time, and so on and so forth. So that's your wills, really. It's important that you consult a lawyer to do it, because these days things are getting very, very technical. And as our society becomes more commercial, people are grabbing after property. But let me throw in a nice thing here for you now. These days, well, even when you're married, you refer to your wife as your partner. Even when you're shacking up, it's your partner. Even when you're courting and hanging out, it's your partner. Okay? All right, so let's assume you were not married, and then you had a will. You know, you had made a will, and then you subsequently married. What do you think happened to that will? Anybody want to just shout and tell me something? No? It's revoked. Yeah. There's a section in the Wills Act, the law that governs wills, section 13, that simply says, a subsequent marriage or a marriage revokes a previous will. A lot of people didn't know that. And so here's some saga boys around, right? So they make a will, you understand? And they set up scenes there, and then they marry, and so on, and they say, well, she ain't really getting one thing, you know, because I set up things across there. But what they don't know, soon as they get married, that will is out, null and void. And it goes on and on and on. It's something that a lot of people get caught with. And that is something we should bear in mind. You know, the next thing, a big problem we face today too, is that quite a few of us, especially those of us who were born after 1950, or even before that, but is that our father's name never ended up on our birth paper. You know that, right? Some of you have had that experience. Well, these days, you know, they set it up in the hospital. The minute you're born, father name go on, but that's some problem, because sometimes some chicks wondering, but which was the last guy dealt with? I'm too sure. and in the circumstances, they say, okay, well, I think I'll put Mr. Johnson's name because he's the manager of a bank, and he could able to mind them children, you know. But these days, father's name go right on. But there's a problem with this one I was telling you about, where father's name are not on the birth certificates. And when people come to realize it's so late, sometimes the father already died, so he can't do an affidavit and get the mother to join with him to give consent that his name added on. So a lot of problems happen especially if you don't have a will, and if this man or woman recognize that this is my child or there, or that is my child. Because if you don't make a will, the other route that the law provides for you is that you would have died intestate, and there's a law called the Intestate Estate Act that clearly defines how the property of a deceased person who did not make a will be distributed. And that is when the confusion really starts. I mean, you have a lot of confusion in will too, because several times a child go in America for 40 years, right, England, and then they leave poor little thing up in Apwe to taking care of mommy and so on and so forth. And mommy make a will and she leave everything for her. They claim they were sending money all along, but you don't see no improvement in mommy home because the latrine still outside, mommy's still in the pre-cut house, and so on. And then they come when mommy die and start saying, that is not mommy's signature, that is not that, and confusion start. And then they want to challenge the will, but then you start telling them now, hey, well, if you intend to challenge that will, you have a cost. Because first of all, you have to get handwriting expert. You have to, it's a lot of technical things that are established to, and then you have, of course, the medical people and so on and so forth. So the problem with, so you have that one there, but in the intestate thing is a lot of sorry story when you die and you didn't make a will, because people come out of the woodworks. And you have situations where you live in common law, for example. That one does be a hard one, because you live with this man for 30 years, right? Upon in the men, right? Because you live with this man for 30 years, right? You wash your clothes, he never marry you. He never marry you. But he probably was married before, right? And he had children of that marriage. And interesting thing, he may not have had a divorce. So the marriage is still what we say subsisting. And then he living with this woman for all these years, and then he died. And what the law say is not a woman he had in the house that have any rights, you know. It's that same wife that he blanked years ago, who now, in terms of the Intestate Estate Act, says has first priority to apply for administration. And she's also entitled, in this day and age, since the law reached up to half of all his estate, and the remaining half goes to his children. And them children, they know we have to start checking, because who in her name on their birth certificate, if they really want to get something, they have to start fighting if those legitimate children do not recognize them, right? And then have to go now to get paternity order to establish that I'm a child of the deceased and so on. So you see problems that can be created down there if you don't make a will? It's, oh, you weren't dead now. Just make an effort. Give us some little more money in your pocket. Come to us. Let's make the will for you. Please. Okay. All right. But there's some other things I want to deal with you. You know, one of the things that I saw when I got this thing from Ms. Berkeley about living trust. Living trust is not something that is very popular in our society. You might find it in America and so on. It's really a trust. It's like the kind of other side of a will, but what's going on, it's not as expensive as the probate. That is, when you have a will, you know, you have to go through the whole process of probate and so on. But living trust is not common here, and in our society is not culturally accepted. I don't know if Sheila has any experience. This is Sheila Harris, one of my colleagues here. But it's not popular. And it's really, it's like you're setting up a trust. You know, a living trust, you're setting up a trust, and all your property you bring in there, and there is someone who, like an executor in a will, who is also responsible for it. And when you die, it does not have to go through the whole process of going to the court to get a grant of probate or a grant of letters of administration to do that. So it's not common here, so I don't want to spend much time on it. But something I want to go on to is power of attorney. That is so important, especially when we have seniors around, and even yourself. So let's take ourselves that we're all bouncy and healthy, but tomorrow you get into an accident, or you, God forbid, or something, and you're incapacitated, right? Let me go less than that. You're going to be hospitalized for a while, and then you realize there are a lot of things you can't do. Then the law provides that you can appoint someone to act as your agent, right? And to do all things for you privately, publicly, and things in law. So we call that document, is a deed, is known as a power of attorney. So John gives Jim or Jill the power to act for him or her in all these areas, and you have to spell it out in the documents. And you know where we often fall down as lawyers sometimes, where we miss, well, I am guilty of this on one or two occasions, is that when we pointing out about the bank, which bank the money in, it seems as though the banks want to find out the bank account number. Sometimes, if you want to be more specific, even the date the account was set up, so they just want to be sure. You know, you have to be specific, right? In that thing, you're saying that she can enter into my bank account at the RBTT Bank in Grandans, account number so and so, to withdraw or to deposit money. So in the power of attorney. So what it does, this person now acts for you to take care of your business in your absence. It doesn't mean that if you're up and you're okay to sign, that you can't go and do the same thing that they're doing. And you can also revoke the power of attorney. If you find the person getting on and jumping up like a jackass, then you really want to say, you know what, I'm going to take this thing back. So you can give someone a power of attorney to act on behalf of you to apply for administration in an estate. If you're an executor of a will, you can also give someone a power to act for you to apply for a grant of probate of the will. When we talk about probate, I was using this word, maybe, you know, it's common to use it. But probate is really a certificate granted by the court, right, that a will is valid, and the executor, therefore, can go ahead and distribute the estate, right? And did I mention the executor? No, let me come back to this point as I'm here. How much time am I doing, Mr. Jones? I'm doing good, a lot of time, okay. Only want me to come down there? Yeah, you know, anyhow. Yes, so I was talking about the probate and the and administration, and the power of attorney. So the power of attorney is something you could consider. It can be revoked anytime by the person who grants it, and it can be given. One of the most common things these days, I notice that people who are overseas would appoint someone here to act on their behalf to apply for administration or to apply for a grant of probate. However, when it comes to the distribution of the property, right, there's some technical things that start coming up, because the person who is the executor could either now apply for another grant, right, or when the property is about to be distributed, he has to join in executing the deeds and so on and so forth. So this could happen. You don't have to be old or older, and you don't have to be, you know, like, whatever. But it's one thing you consider if you do not want to act. If you feel timid, just appoint somebody else to act on your behalf. Now, I want to go back to the issue of the land distribution. In the letters of administration, in the intestate, if you die without making a will, sometimes families come together very well, amicably. There's no quarrel. They recognize those who were born outside of the wedlock, and they do things. Similarly, in a will, if a will says specifically, I give John this property, right, it doesn't mean that John will have to go specifically to have the property for himself. If John wants, when it's time for distribution of that property, he can decide, I want to give so and so, my other sister and brothers, the property. Right. There's another thing about wills too. In a will, you can give somebody a life interest in a property. You can also do that if you're making a deed, but let me deal with the wills. So you could say in your will, I give A, right, my property at Grandans for her life, and after to my children in equal shares. But please mention the names of the children specifically, okay? Because that could be a problem again, okay? So you want to do that. So it goes back now to the intestate. If you die without making a will, although the law says this. So the first thing, if a husband and wife, if the husband dies and leave the wife and there is no children, the wife is entitled to half the property. And the remaining half is there until They could find out anybody is entitled. If nobody is coming together, then it goes to the crown, right? If the wife doesn't, or it goes, the wife gets all of the surviving spouse. If the couple had one child and one dies, half the share of the property to the surviving spouse, the remaining half to the surviving child. If no parents, right, both parents die, then the property goes to all the children in equal shares. Again, that is not printed in stone for the people themselves. That's what the rule is. And if everybody wants the equal shares, okay. But somebody else could say, and it often happens, that I don't want anything, right? I just want to give it to the others. But of course, you can't just say that and it's going to be done. When the deeds and the transferring is taking place, you must sign, you must join in so that you show your consent to stuff like that. Okay? All right? So all I would advise you is that while we're up and kicking, one, you should consider, you should gather your properties and see what I have, and consider making a will or consider giving them away in your lifetime. Right? If you know you have your lovely jewelry and so on, and you have your favorite daughter or son, and you want to start getting rid of it because you know it could create confusion, just give it away in your lifetime. The minute you shut your eye, all hell roll loose, because people will just run and start grabbing property, and this is it, and this is mine, and this is the other. So consider making a will, and if you don't want to consider it, then that's cool. But remember, if you had a will and then you get married, don't forget that will is out of the window. So you got to make sure. And if you divorce and then you marry again and you had one there, that one gone, the next one coming up. So these are some of the information I want to just leave with you this evening, and I am open for any questions down the road. Thank you.
Well, thank you very much, Ferron, and let me assure you, it wasn't me. But this whole thing about will and leaving property for your children and jewelry, I particularly like the idea of giving away everything you have before you die. That is me. I like that idea. But I want to share with you a little story. There was this guy. He was a very wealthy farmer. So he had lots of lands, lots of farmlands, lots of machinery, tractors and so. He had about 3 properties. And then in his late 70s, he realized he was going. The doctor said, well, you have about 2 more days to live. So he called his 3 sons around him. And he said, boys, your papa going. But I have so much thing. I want to know what's going to happen to them. He said, we're going to take care of all them tractors and trucks that they have. The youngest boy said, me daddy. Oh, okay, son, good. And who's going to take care of all them farms that I have, all them cocoa and nutmeg farm? Me daddy, said the youngest son. And who's going to take care of them 3 houses I got? Me daddy, youngest son again. And who's going to take care of the 2 girlfriends? No, he didn't say that. But he said, and who's going to take care of the $1 million loan I got at Republic Bank and the $500,000 overdraft I got at RBTT Bank? Who's going to take care of them? The little boy turned to the brother and said, what happened? Y'all ain't going to take something now? Anyhow, so on that note, I will invite Ms. Chanel Andrews to give her comments on the presentation by Mr. Lowe. Ms. Chanel Andrews.
Good night, everyone. I must state I'm not a lawyer, and I have no intention of being one. But Mr. Lowe, you did a very good job on your presentation. You shed a lot of light, especially the part with marriage. Sometimes you make a will, you get married, and you think your will still stand. Unfortunately, it does not. Now, education is very important. It's one thing when you know what you're doing, and it's one thing when you don't know, especially when it comes into these legal matters. That's why sometimes we have to go to the experts to seek advice. I remember when I walking into the room, Mr. Johnson, you spoke about your child. I can't remember if it's son or daughter. Asking if you have a will. Daughter, right. I remember my brother in school, my little brother, asking me, Chanel, you have a life insurance? And my response was, well, kill me now. And you'll find out. So the younger generation, we notice that they are more educated when coming to wills and these things. They plan ahead for you. Sometimes you close your eyes and confusion starts, as Mr. Lowe said. If you have one child, it's straightforward. But sometimes when you have more than one children involved and other families, the larger families, you tend to have a lot of conflict and chaos beginning. So I'm going to talk in terms of the financial aspect. You start to work or you have some money, you open a nice account. Now, there's two main types of financial institution where you go to open accounts. There are the credit unions and there are the banks. And both of them, the processes are similar to some extent, but can be different in terms of beneficiary. At the credit union, when you open an account, they would ask you if you would like to put in a beneficiary on your account. And in most times, you can put more than one beneficiary, and you can state, I want my son A get 50%, the next 50% go to other party, or 20-20 down the road, or whatever ratio you choose to share, or sometimes you just put one beneficiary and make it straightforward, right? In some instances, if you do not have a beneficiary on your account, and God forbid you close your eyes, we would ask for a letter of administration. The bank is the same. If you close your eye, they would ask for a letter of administration that you may have, or a will, to decide who's going to get the property. That's what you would have put in place. If you don't have that in place, you have to go to the experts to get the monies out, and it can be a very tedious and difficult process. Now, there's something in the credit union that is different and unique from the other financial institution, where we call something called LPLS, which is like an insurance. It's a life protection, loan protection, and savings protection scheme kind of that's in place. If somebody that, God forbid, you close your eye, the older you die, the less in terms of the claim for your beneficiary. For instance, if you die before 55 years, the person would get up to $13,500, full 100%. If you die between 56 to 60 years, 75%. I hear people laughing. 61 to 65 years, 50%. 66 to 70, 25%. Over 71, you get 0%. Because technically, over 70 years, the life expectancy drop, right? Sad but true. It's your beneficiaries benefit better if you die early. I'm not saying that, but that's the reality, right? Another trick to it now, you must claim after 3 months, approximately 3 months after the person died, you would claim. If we are notified of the death after 2 years, no claim is received on the account. Now, I'm not talking about the saving money the person would have. You would have your savings of $10,000. That the claim, you would get a claim up to $13,500 based on your age, and that claim could double if you die by accident, sudden death, right? If natural cause, you're sick, and so it would not double. And most time, persons get confused because they hear you open an account in a credit union, if you die, the money doubles and your beneficiary gets it. They don't hear the part in terms of your age when you die, and they don't hear based on what circumstances as well in terms of the doubling. So you would get your savings that you work hard for and put in the credit union. You would get your claim, which is in addition to the savings you had. The claim is not monies you would have put there. It's like an insurance money your beneficiary getting. That is what the claim is about. I'm not talking about reducing your savings money that you put in the account. I'm talking about reducing on the claim, right? The beneficiary on the account is the only one who can claim legally unless a probated will or letter of administration states otherwise, right? And you must present a certified copy of the death certificate. That is very important. And if you go to the banks to claim whatever savings on the account, you would have to have a death certificate as well. If no claim is made, the funds are retained in a holding account at the credit union. I'm back on the credit union, right? No claims after 7 years. If there's no claim after 7 years, the monies go back into the credit union's account, right? In terms of the doubling, let me just explain it clearly so you'll understand, because I know that's a very confusing part for persons. If the member dies at age 50 years, your savings is $13,500. The beneficiary will receive the $13,500. That's the money you worked hard for and put in the credit union. Plus, you would get a claim, I'm talking about accident death here, a claim of $27,000, which is the $13,000 again by 2, because the money is insured up to $13,500. If you had $20,000 on your account, you would not get $40,000. You would only get $27,000, because that insurance is only up to $13,500. Am I clear enough? Okay. I know it's a little difficult. Persons tend to be confused, especially with the age range. And you have to find out about the age range, because the older you die, the less the claim gets. And I'm not talking about your savings again, right? Now, at the bank, as I said, pretty straightforward. After 7 years, the money would go to the Eastern Caribbean Central Bank. All right? So it's important to have beneficiary. It's important to go to the legal experts to do a will if you don't have beneficiaries on your account. And that would save a lot of drama, because you never know what would happen. Right? Thank you.
Thank you. Thank you very much, Chanel. I think if Linda were up here, she would just clarify something, that it is after 15 years that unclaimed funds from a bank would go to the central bank. I mean, maybe they'd like to have it at 7, but for now it's 15. And there's something called the small estates. I don't know if it's an act or bill, but for example, if you have an account in a bank and you die and the balance is, let's say, $5,000, that is considered a small estate, provided you don't have any other assets. So if your next of kin comes into the bank with a death certificate and says, well, my husband died, he only had $5,000 in the bank, he has nothing else, he owns no home, he has no car, nothing else, this is all he has, that money will pay to you, provided you sign certain indemnities confirming that what you said is correct. So just by way of clarification. Now, I'm sure there are some more questions out there among the audience, particularly the ladies. The ladies want to know what they will be getting when their husbands die, so yeah. I know we have lots of ministers of home affairs out there. Yes, all the ladies are ministers of home affairs. Yeah, take care of the homes. Okay, you're probably saving your question for after the last session. But we have a question, okay.
Right. Good evening to all. I have 2 questions I want to ask Brother Ferron Lowe, please. Could you clarify for me a statement I heard that if my husband dies or a wife dies and leaves no will, that the property, 50% of the property goes to the spouse, the surviving spouse, and the other half goes to the crown?
Okay, right. if they're
No,
children,
without
no
children. That's what I thought I heard,
No
right?
children, yeah. Yeah. What? Oh, okay, go ahead.
50% goes to the spouse, the surviving spouse,
Yeah.
and the other 50, does it go to the crown?
It could.
Because you said unless somebody
Unless,
comes to
yes.
claim
Yes.
in a couple of years,
Yeah,
yeah?
what's happening is that somehow that first subsection says 50% to the surviving spouse, and the remaining 50% would devolve if, and it goes down, no other one come forward to claim, and if no one, right, then it goes back to her, by the way. She will get all. But let's assume, right, that the person died and there was no one to benefit. Then you know what happened? It goes to the crown. But in other cases too, it goes, what we call the crown because that's what it wants. It goes back to the state.
That is very new. I just thought that if my husband dies,
Yeah.
all that he has,
Well, eventually,
without any question, without any children, that everything comes to me.
it comes to you.
That's what I thought.
Eventually,
without
it
any.
can. Yeah, it can.
Right. Okay.
But all right. So that's one.
Right. The other question is, I am part of a health plan at my workplace that has a proviso that if I die, I get whatever it is, and I'm supposed to name beneficiaries. Okay? If I die with a will, how does that? What happens in that case?
Right. Well,
Does my beneficiary under my health plan stand against the will?
Yeah, no, that's a separate thing apart. It's like your insurance.
Okay.
The beneficiary there is like stationary.
Sacrosanct.
Right. Yeah.
So it doesn't
So no, it doesn't tamper it now.
with the will. Okay.
Right.
Thank you.
No. At the same time, there is something in wills. If you make a will, and you forgot to mention properties in the will, okay, and you also inherited properties that you didn't know about. Somebody left properties for you otherwise, right? And if you do not have what we call in a will the last clause, any lawyer you go to, you must always remember this. You need to put in a residuary clause to take over what we call the residue. These are things that you forgot you had. You didn't put in the will. Then this clause will say, I give, devise and bequeath all the residue of my estate whatsoever and wheresoever they're situated to so on and so forth. Now, if you don't have that, you know what happened to those properties that you didn't mention? You didn't lose them, they still belong, but you go on what we call an intestacy. You have to deal with them under the Intestate Estate Act because they were not mentioned in the will. And there was no residuary clause to pull them in. I hope that explains the question. Thank you.
Thank you very much. More questions from the audience. Come forward, please. Seems you have to line up now.
Good afternoon. You mentioned
Good evening.
something about living trust. We're living in a global environment now. Can you say a little bit about that, please?
Well, as I was pointing out, it's not common here. And the truth is, we have not had, that's why I was calling on Sheila a while ago to ask if she had ever had an experience doing a living trust. No, she hasn't, and she has been in practice for several years too, and she's in one of the reputable firms in St. George's. But the living trust, all right, let me use an example, another kind of example, like a deed. There might be children who are pretty young, and there's a law, the law says that if you're a minor, you can't really own property. Okay, so now that we move it up to 18, it's 18 now, right?
Yeah.
The age of majority, right? So you can. So you could. But you left in a will. I give to my 4 children so and so, but 3 of them are minors, right? Now, when the executor, if you want to pass the property to these kids, you must establish in that deed a trustee, somebody who will hold the property for them. So the deed will read executor, trustee, beneficiaries, or whoever it is, and so on. So that's the kind of trust that we know about in terms of setting up land. But the living trust now is like it's a document not similar to a will, but does not have the same effect as a will. And in there, you pass all the property onto the trustee, who sometimes is yourself. And you could deal with that property anytime, all the time, you know, and don't have to wait at the end of a period when someone dies to get rid of it. So even after, so when the person who's given the trust, in the living trust, even if that person becomes incapacitated, right, and so on, the person who is responsible for managing the trust can continue to do all that the person who gave the trust was doing. Unlike if it's a will, you can't do anything until you probate the will. But I should qualify this. There are a number of things that an executor can do, right, as soon as a person dies. He can gather all the assets, pay the debts, pay the funeral expenses, etc., etc. Go to the bank with the will and so on, and to get relevant. But one thing that they can't do before they get probate or administration is to distribute real property. They can't convey that. So the living trust is just a little bit different in that you could continue to do anything with, and it is less costly than if you had to go to probate. But I think because the society is changing and we will find out people are coming in to deal with that, because it's really private. It keeps your thing very quiet. A lot of people don't know your business in that instance at all. Yeah.
Thank you very much. Time for one last question for this session.
And it's an important question. All right, so a husband and a wife, right, so they're living together. The husband makes a will, but the beneficiaries are only his children, and he did not include his wife.
Right.
So he passes away. What happens to the wife then?
Well, the law has moved to the stage where the wife can now go to the court and ask the court, well, at least, you know, that, look, I have made contribution to this home. I have been responsible for that man reaching where he is to. I'm putting it in very local terminology. And the law now provides that they will really make sure that you get something from that estate.
Thank you very much.
Yeah. So not yeah.
Yes, indeed. The Minister of Home Affairs must get her due. Okay, so we move right along, and thank you very much, Ferron and Chanel, for a very lively discussion there. Thank you very much.